Kathy Mitchell. If you would, please come forward, state your name, who you're here representing for the record, please.
My name is Kathy Mitchell, and today I am representing the Texas Criminal Justice Coalition. There's been a lot of discussion here today about the things we don't know about civil asset forfeiture, and that was sort of going to be my topic. We already know that this process challenges our ideas about what should be constitutional in the taking of private property by government. We also know that there's wide variation statewide in the use of civil asset forfeiture, that some jurisdictions rely on the money for core funding. That looks bad, but in tough times, do we really care if we fund our police and prosecutors from drug lord coffers? Maybe we don't. Some say we care because of the principle of the thing, and I do care about that. But you want to know the harms, and that is where the data that we have falls short. Right now, asset forfeiture operates under essentially a veil of secrecy, whether it's an accident of reporting or the accumulation of reporting that doesn't really say much. Whether asset forfeiture mainly targets cartels and drug lords, or do most busts seize small amounts of money from minor violators? That's a key question that's very difficult to answer from anything we know now. To what extent are innocent people victimized by police and prosecutor overreach? We've seen anecdotes, but we don't have data. How often do police seize cash and cars after impromptu searches at roadside stops? And based on what we've heard today, what exactly is this nexus of circumstances thing? How many people have assets seized even though they're never charged of a crime? That's a key piece we've heard a lot about today. How many people lose their stuff simply because they can't afford a lawyer or do not secure counsel because the lawyer would cost more than the stuff is worth? We don't know whether or how often taking people's cars, money, and sometimes real estate, this is going to sound very racy, help prosecutors coerce a guilty plea in a criminal case. Federal guidelines prohibit this. But where's the enforcement? Jurisdictions around the state have had some debate over where the ethical lines really are, and the plea process is opaque. Texas civil asset forfeiture cases where property is represented by an attorney sometimes settle with a cash split, returning part, but not all, of the money to the owner. Why? Is the state filing poorly supported forfeitures, or are they taking such small amounts that DAs don't want to spend any time on it if an attorney shows up? We don't know the answers to these questions, and these are key questions. Indeed, since most prosecutors can only speak about what they do in their own jurisdiction, and we've already seen there's enormous variation in the use of this tool statewide, even prosecutors can't really answer these questions for state policymakers. When lawmakers have tried to pass legislation that would address the shortcomings in what we know, prosecutors and sheriffs have opposed these efforts. Last session, more than 24 law enforcement agencies opposed a relatively simple bill to require existing audits of asset forfeitures to tell us whether the cases are associated with a criminal case and what happened with that criminal charge. If indeed civil asset forfeiture is largely a procedural way to take money from drug lords, then public statewide data on the criminal cases associated with civil forfeiture should reassure the public that abuse is not common. Does the information we want exist? Yes. Most of it is sitting in county courthouses around the state and is almost certainly tracked by most prosecutors. The Texas Criminal Justice Coalition believes that the opacity surrounding asset forfeiture helps cover up abuse and contributes to public distrust. It also makes your job harder, since policymakers must base their judgments on anecdotes and not data. TCJC strongly agrees with many others that have testified today. Forfeiture should be limited to people convicted of crimes. Sharing agreements should not be used to get around state requirements. That said, forfeiture is big business in Texas, so we think more and better public reporting would make these issues much easier for the legislature to regulate and the whole process more accountable to the public. Any reformed forfeiture system that still allows government to routinely seize money from people must both comport with the Constitution and be transparent and accountable.
Thank you for your testimony. Representative Canales.
You're talking about anecdotes, and I just want to share one with you. I recently represented somebody in a forfeiture proceeding, and the discovery responses that I got from the state said, do you have any witnesses? None. Do you have any witness statements? None. Do you have any nexus that supports the contention that my client? None. Do you have any documents? None. Anything? None. We walked out of the courtroom, he says, just settle with us for half. And I've lived it, I've seen it, and I know there's a lot of people doing the right thing, but I firsthand have seen the other side of it.
Yeah.
And I do think that we need some reform, so thank you for being here.
Thank you.